Last month's video, I talked about the new removal statute, which has now been signed into law by Governor Walker and is now the law of the land. So this month, I'm going to talk about two other pieces of legislation that have some effect in family law. I don't think either of them have major effect, but it's enough worth mentioning. And let me start by saying that it's not a coincidence that all of these happen at one time. I've had a little bit of experience in dealing with the legislature. Someone, as I mentioned in the previous month's video, on the removal law following the Kirkfleet case, some on some of the property divisions, and my most proudest moments, I guess, is what's the automatic stay statute, my pet project for a number of years. And one of the things I learned in terms of working with the legislature is that everything is done last minute. And there's a 2-year legislative session, and all of a sudden everybody runs around like a chicken with their head cut off, and bills get passed, and things are flying around, and it's just an amazing anarchic is the wrong word, anarchaic. How about just old? How about that chaotic? That's the word. Chaotic system that goes on in terms of getting bills passed. It's the old Will Rogers line. There are two things you never want to watch get made. Sausage and laws is really, really true. And to some extent, it's going to affect a little bit in terms of the two laws I'm going to discuss today, in terms of that the process is more political than legal, in the sense that a lot of what gets done may or may not be helpful or even an improvement in our law, but they're being passed by politicians. I don't know about the last session of the legislature. I know that when I was working on the automatic stay statute, of the 133 legislators from Wisconsin, 100 state representatives, and 33 senators, at that time there were 9 lawyers. So 124 of the 133 were not lawyers. And as I recall from last session, it wasn't many more. There were maybe a dozen that were lawyers, and of them, only a couple who had ever practiced law in their lives. So that's what we're sort of dealing with, and that's why some of these laws that get passed may or may not be the greatest ideas in the world, but we still have to deal with them. Neither of these laws that I'm going to discuss today are bad, are negative, but both I think lawyers should be aware of and taken, I think, with a few grains of salt. The first one is 2017 Wisconsin Act 272, and it is known familiarly as Saras Law. Sara is Sarah Court-Sann, S-A-N-N. Sarah Court-Sann was a lawyer in Wausau, and among the horrible things that happen in family court is when someone to a divorce action loses perspective, perhaps mental illness is involved to a certain extent, and decides to punish other people involved in it. Frequently it's their spouse, but sometimes it's the lawyer, and the results can be catastrophic. I spent 7 years as a prosecutor in Milwaukee County, 4.5 as a felony prosecutor. There was never a moment where I feared for my safety. First of all, when I'm in court, there were police all around. It was never a problem, never a danger. And out on the streets, criminal defendants aren't looking for prosecutors. If they're angry at anyone at the end of the case, it's probably their own lawyer. But it never bothered me and never created any concern. It's not the case in family law, and there have been a number of instances in this country where someone going through a divorce transfers the blame from himself or herself, and if they throw out the genders, it's almost always the guy, and takes it out on others. And that's what happened in the case where Sarah Court-Sann, who did a lot of guardian ad litem work, in this particular case was representing a woman in her divorce. And in March of 2017, he went into her place of work. When workers tried to shelter her, he killed 2 of them. He then went over to Sarah's office, found her, shot her to death, and then died in a suicide by cop. I forget if he shot himself or if he was shooting at the cops and they killed him, but the end result's still the same. Wisconsin, 2017 Wisconsin Act 272 makes it a felony for someone to threaten bodily harm or to cause bodily harm to a lawyer, guardian ad litem, or corporation counsel involved in family law actions. It's well intended. If the law does something to honor Sarah's memory, it's a good thing. It certainly doesn't cause any harm. But I'm a little skeptical of the law. If you have somebody like the man, and I don't even want to use his name, who did those horrible acts up in Wausau a year ago, March, this is somebody who wants to die. He wants to either kill himself or be killed by the cops. And so making those acts into a felony and saying you could be sentenced to jail and fined and convicted of a felony isn't going to stop anyone. Because A, they're not thinking rationally for one thing, and second, moreover, they want to die, and spending time in prison isn't going to happen because they're either going to be killed by the cops or kill themselves. Certainly there are things lawyers need to learn from this in terms of security, in terms of trying to recognize those rare cases, fortunately rare, but they do occur, and also having safety procedures for both themselves and for their law staff. The other law that passed that has some minor implications on family law, but enough to mention it, is a law that affects discovery in Wisconsin. It's 2017 Wisconsin Act 235, and this law makes a couple of changes to Wisconsin discovery law, both which I think are good changes. They don't affect a whole lot of what we do in family court, but it does arise from time to time. The one that has the least effect is it restricts the number of depositions to no more than 10 in a case and no more than 7 hours per deposition without permission of the court, presumably for a case that's especially complicated. The rare instances when we have to do a deposition, I always tell the court reporter that we're not going to get, the court reporting firm is not going to get rich over my office. We rarely do depositions, and rarely do we have our clients deposed. For the most part, it's just sort of a waste of time. And I think lawyers who do it with the concept that you're protecting yourself is wasting the effort. There's a requirement in Wisconsin, of course, that both parties disclose on financial statements at the beginning of the action, and then update them at the time of trial under oath that they have disclosed all assets with a value more than $500. If they haven't done that, they're subject to the non-disclosure rule and the sanctions set forth in the statutes, and probably contempt as well. And having a deposition spending the money seems to be a waste of time, because I can't imagine someone's going to come into the deposition and say, oh, well, yeah, now that I'm here, I'm going to tell you about the offshore bank accounts that I wasn't going to tell you before, because now you got me, you got a court reporter, and I've been sworn under oath, and I just don't think that's likely to happen. So I don't think that rule affects a whole lot of cases. When there are depositions, they're relatively rare. They tend to take a whole lot less than 7 hours, and I don't think I've ever had a case in all the years I've been doing this where there have been anything even close to 10 depositions. The other rule that changed, though, is more applicable, because this does happen, which limits the number of interrogatories to 25 in an individual case. Again, absent court permission, that the case apparently requires that many interrogatories, and the 25 include subparts. Statute doesn't change that much of local practice, because a lot of counties have local rules that restrict the number of interrogatories. And again, I find that that rule is helpful in cases, and more helpful, in fact, than the deposition one, because again, if someone's going to lie, if they're hiding money, if they're committing fraud, and if they're committing perjury in their financial statement, answering a question under oath isn't going to get them to say, oh yeah, well, now you got me. I wasn't going to lie. I was going to lie in my financial statement, but I won't lie in this interrogatory. If they're going to lie, they're going to lie, and you're not accomplishing anything or doing anything. There's some rare cases where there's some specific questions that can be asked in interrogatories that might be helpful, but again, it's the rare case. In most cases, I don't think interrogatories are really helpful to lawyers, and I think, quite honestly, in most cases, they're a waste of our clients' money. That being said, I do like the statute. I think it's establishing a number, and that if anyone wants to ask more than 25 interrogatories, they should get court permission to do it. Just as an aside and for fun, a number of years ago, I had a case and I was served with a large number of interrogatories. It was a case where the other side didn't need it. They were just running up fees. And fortunately, I had a judge who I knew pretty well and I thought might be able to put up with my sense of humor. And so the first question in the interrogatory was, state your name. And our answer was, I've been married to you for 32 years. Why haven't you learned my name yet? Question 2 was, do you have any children? Answer, do your children 2? 3, state the name of the children. Answer, don't you know them? The other side brought a motion to compel and made some comments about the answers and our responses being sarcastic. And the judge said, if you ask a stupid question, you're going to get a sarcastic answer. To make someone work under oath and tell them the name of your children when you should know the name of your own children, you were just spending extra time and doing extra work, and denied the motion. So sometimes, if you're the right judge, you can make the other side look bad. That's of course not our goal anytime in divorce. It's better, I think, what the statute does, which say if you want to ask interrogatories, there better be a limited number, and therefore you ought to choose real carefully that the information you're seeking is something that's relevant and necessitated to do this process under the circumstances, because interrogatories are expensive to do, and they're expensive to answer, and I think in most cases, I say, is not an efficient use of our clients' money. Speaking of efficient use of money, I do want to close this again by mentioning that our family law case finder is now available, and what it is a collection of cases from Wisconsin over the last 35 years. Should have, our goal was, and I think we have all Wisconsin family law cases, many other cases from around the country, and other resources in there. It's indexed, it's searchable, and it's I think a remarkable tool. And after many years of using it purely in-house here at this law firm, we are now licensing it by subscription to other attorneys. It's called Wisconsin Family Law Case Finder. There's a link to it at on the screen as I'm talking. Take a look, click on the link, go to it, there's more information, and I think it's something that you'll find very useful, and probably more useful than the statute limiting depositions to 70 hours in an individual case. Thank you for your attention today.